following video is a presentation of the Alcohol and Tobacco Tax and Trade Bureau of the United States Department of Treasury. The Alcohol and Tobacco Tax and Trade Bureau, or TTB, regulates and collects the federal tax on alcohol beverages in the United States. One aspect of this regulation is the enforcement of what are known as trade practice laws and regulations, which are designed to promote a level playing field among industry members, as well as to help ensure retailer independence. This video series will explore sections of the trade practice regulations, including tied house, exclusive outlet, consignment sales, and commercial bribery. In this video, we'll discuss arrangements that are prohibited under the consignment sales rules and regulations. We're presenting this information to help you understand and comply with the laws and regulations that TTB administers. This video does not establish any new or change any existing definitions, interpretations, standards, or procedures regarding those laws and regulations. Also, this presentation may be made obsolete by changes in laws and regulations. For the most current requirements, please consult the applicable laws and regulations, which are available at our website, ttb.gov. Throughout the presentation, you'll see references to 27 U.S.C., which stands for Title 27 of the United States Code. That's where the trade practice laws of the Federal Alcohol Administration Act, or FAA Act, are codified. You'll also see references to 27 CFR, which stands for Title 27 of the Code of Federal Regulations, and that's where the Federal Trade Practice Regulations are codified. Now, as you go through the video, please make note of the citations that are made to either 27 U.S.C. or 27 CFR. That's where you'll be able to find additional information and the full text of the specific law or regulation cited. Under consignment sales rules, it's unlawful for an industry member to sell, offer to sell, or contract to sell to a trade buyer, or for the trade buyer to purchase, offer to purchase, or contract to purchase alcohol beverages on consignment, such as an arrangement where a trade buyer is under no obligation to pay for products until they're sold, or under conditional sale, or with the privilege of return, such as an agreement made that whatever the trade buyer can't sell can be returned to the seller, or on any basis other than a bona fide sale, or if any part of the sale is conditioned on the acquisition of other distilled spirits, wine, or malt beverages from the trade buyer. The regulations covering consignment sales are found in 27 CFR Part 11, while the law can be found in 27 U.S.C. Section 205D. The consignment sale rules are different from other trade practice rules discussed in other videos in two significant ways. First, both parties to the transaction can violate the consignment sales provisions. Second, the consignment sale provisions apply to both industry members and trade buyers. Generally, when we refer to an industry member, we mean anyone who produces, distributes, or imports alcohol beverage products. A trade buyer can be a retailer or a wholesaler. So these regulations apply to arrangements between industry members, such as a producer and wholesaler, as well as between an industry member and a retailer. It's very important to remember that when a consignment sale violation arises, both parties to the sale are in violation. That's because it's prohibited both to sell and to purchase alcohol beverages on consignment. There are some exceptions that allow for the exchange or return of product for ordinary and usual commercial reasons. The reasons considered ordinary and usual are specifically listed in the regulations, and they include delivery error, defective product, such as products under voluntary recall, leaking containers, or damaged labels, and product that is unlawful to sell, usually due to a change in regulation or a particular size of container or certain brand is no longer permitted to be sold. Products may be returned for cash or credit against outstanding indebtedness, where a retailer or wholesaler is going out of business or terminating a franchise. This exception does not apply to circumstances in which a retailer sells alcohol beverages at a special event and then continues to retail at another location after the conclusion of the event. In general, this exception only applies when the retailer or wholesaler is completely terminating its operations or franchise agreement. When there's a change in a product, such as a reformulation of an alcohol beverage or change in the ingredients, the trade buyer may exchange its inventory of that product for equal quantities of the new version of that product. Product that has been discontinued by the producer or importer may be returned for cash or credit against outstanding indebtedness. In addition, the seasonal dealer's exception allows a seasonal dealer whose establishment is only open during a portion of the year, such as only open during the summer or during the winter months, to return products if those products are likely to spoil in the off-season when the establishment is closed. Although some beer may spoil during the off-season, it's unlikely that distilled spirits will. So this exception is unlikely to apply in the case of distilled spirits. TTB regulations also list 2 reasons that are not considered ordinary and usual reasons for return, and they are overstocked or slow-moving product and seasonal products. That is, products for which there is only a limited or seasonal demand, like certain flavors, styles, or packaging that is specific to a certain time of year. TTB has issued rulings that describe the circumstances under which malt beverage products that have been deemed unsuitable for sale because of freshness concerns can be returned without violating the consignment sales provisions of the FAA Act and the TTB regulations. TTB will allow the return or exchange of malt beverages for freshness reasons subject to certain specific criteria, one of which is that the product may not re-enter the retail marketplace. The specific criteria are intended to minimize the possibility that the industry will use freshness dating returns as a subterfuge for disposing of slow-moving products. For the most up-to-date information, please visit the TTB website at ttb.gov and search for TTB Ruling 2017-2. Examples of consignment sales are: a wholesaler sells 300 cases of beer to a retailer with the understanding that it can be returned if it doesn't sell. Or an importer sells 200 cases of wine to a wholesaler under the condition that the wholesaler doesn't have to pay until the product is sold to retailers. Under federal regulations, there are certain elements that must be present to prove a consignment sale violation. First, there must be a consignment sales arrangement. An industry member sold, offered to sell, or contracted to sell to a trade buyer, or a trade buyer purchased, offered to purchase, or contracted to purchase alcohol beverages from the seller on consignment or under conditional sale, or with the privilege of return, or on any basis other than a bona fide sale, or if any part of the sale is conditioned on the acquisition of other products. Second, we have to show that the activities occurred in and had an effect upon interstate or foreign commerce. That means that the sale, purchase, offer, or contract was made in the course of interstate or foreign commerce, or the practice substantially restrained or prevented transactions in interstate or foreign commerce, or the direct effect of the practice prevents, hinders, restricts, or deters others from selling their products to trade buyers in interstate or foreign commerce. Because consignment sales violations do not require exclusion as an element of proof, the primary clause does not apply. Because most alcohol beverages are sold in interstate commerce, this element generally is not difficult for TTB to establish. For more information about this element, please watch our other video, FAA Act, History and Background. The third element applies only to transactions involving malt beverages, and that is, there must be a similar state law. So what does that mean exactly? Well, basically, for trade practices that involve malt beverage products, TTB must show that there is a state law that is similar to the federal consignment sales statute in order for the federal rules to apply. Note that the law does not have to be exactly the same. There is a very broad interpretation of what constitutes similarity. And a similar state law does not have to be strictly an alcohol-related law. Such laws can be found in the state's general business rules. Remember, similar state law is only required for transactions involving malt beverages and does not apply to transactions involving distilled spirits or wine. If TTB cannot establish all of these elements, TTB cannot prove a violation of federal law. State laws may be different, so make sure that you're familiar with the laws in the states in which you operate. There are two things that are important to remember about consignment sales. First, TTB does not need to prove exclusion if the sale, purchase, offer, or contract is made in the course of interstate or foreign commerce. And second, if there is a consignment sale violation, both parties to the transaction have violated the consignment sale provisions. If you have any questions about the consignment sale regulations or what practices are covered, please send an email to tradepractices@ttb.gov. And make sure to watch our other videos which discuss the FAA Act history and background, tied house, exclusive outlet, and commercial bribery.